We are deeply grateful to Mr. Salman Khurshid for agreeing to deliver this great lecture in memory of eminent legal philosopher Professor Ronald Dworkin, who was his teacher at University of Oxford. And we are equally grateful to Honorable Mr. Justice A.K. Sikri, who is presiding over this function. Justice Sikri is a great scholar judge, and we are thankful to our colleague Professor Yogesh Pratap Singh and Professor Shruti Bedi for joining us in this great event. I look forward to hearing the scholastic lecture of my mentor, Mr. Salman Khurshid, and welcome you all to join us on this occasion.
Thank you so much, Dr. Lokendra Malay. In fact, I was just going to introduce you, but thank you for the welcome. So, ladies and gentlemen, good evening. I welcome you all to the Professor Ronald Dworkin Memorial Lecture, which has been organized by the Ronald Dworkin Study Circle and the National Law University of Odisha. This lecture would be delivered on the topic of democracy, dissent, and Indian Supreme Court, and it is going to be delivered by the eminent Mr. Salman Khurshid, former Union Cabinet Minister for External Affairs and Law and Justice. It will be presided over by Honorable and currently a judge of the International Commercial Court at Singapore. Well, in the galaxy of legal jurisprudence, Professor Ronald Dworkin is one of the brightest stars. In fact, his prolific, the world tennis champion Roger Federer, who continuously has to defend his title and has to work insidiously at every cost. So as a tribute to his legal scholarship, of the legal scholarship of Professor Ronald Dworkin, Mr. Salman Khurshid and Dr. Lokendra Malik, in fact, brought out a book on dignity in the legal and political philosophy of Ronald Dworkin. I have the book here with me, which you can all see. Dr. Lokendra Malik is in fact a unique mix of academics and advocacy, and his zeal and passion for contributing to the arena of legal literature is unparalleled. And you can see that from the 10 books that he has published. It has been an honor for me to be associated with him in different academic ventures. And in fact, I think he is the glue which joins academia and lawyering. Dr. Malik has already extended his welcome to the guests this evening. So I will move on to the most important part of the evening, which is the lecture on in the memory of Professor Ronald Dworkin by Mr. Salman Khurshid, senior advocate and former Union Cabinet Minister for External Affairs and Law and Justice. Mr. Khurshid is an effortless cerebral scholar. His illustrious brilliance as a thinker, as an author, as a playwright, and as a politician, as an advocate, and most significantly, as a student of Professor Ronald Dworkin himself at Oxford, will be the perfect antidote to the stresses and strains of this pandemic. So without further ado, ladies and gentlemen, I present to you Mr. Salman Khurshid, who will be speaking on democracy, dissent, and Indian Supreme Court. Mr. Khurshid.
But hopefully we will get through.
Right, sir.
I am I need to particularly recognize Justice Sikri, because I do believe that there has been a remarkable contribution made by Justice Sikri in recognizing the work of Ronald Dworkin in judgments of the Supreme Court, and I believe that that has laid the platform for much more to happen in the future. But what encourages me enormously today is his recent association with the Supreme Court and the judgments, and the things that I believe are still somewhat open-ended, is something that, as a former judge of the Supreme Court, will be very interesting to see how he reacts and responds to some of those ideas. And of course, in the presence of so many important people, including you, I will make this into a brief talk rather than enormously long lecture, so that we can have both the reactions from Justice Sikri, as indeed from other people, questions that could be raised.
Right.
I have a perception of the Supreme Court that would be a little provocative for scholars and for judges, that I'm placing before you. I believe that would be the true tribute to a man like Professor Ronald Dworkin, whose work challenges the fundamental understanding of the judicial system and of the judiciary, that it charts out new areas which are exciting, which are exhilarating, and at the end of the day, I believe that they are profoundly influencing of the decisions that we will see in the years to come. The fundamental point that I want to touch, this is not a lecture to explain everything Ronald Dworkin believes in, but the fundamental point that I want to touch upon are two. One, that I believe in the limited opportunity that Justice Sikri had, and Justice Chandrachud, who is still on the bench, had of looking at Ronald Dworkin's theory of rights between the two eminent judges, one looking more towards rights being successors of rights that are pre-constitutional, that there are things called natural rights, and those natural rights then get translated into formulations in the Constitution, and therefore they become constitutional rights. And looking the rights thesis that Justice Sikri has looked at, I believe is somewhat different, is more analytical, what I believe Dworkin had in mind. The second important fact that I want to make before this very august audience is that 25, 30 years after the class judges of our court, which included Justice Chandrachud's father, who was to go on to become Chief Justice, and of course Justice Bhagwati, who went on to become Chief Justice, is the ADM Jabalpur. It's being talked about in recent times because of the anniversary of the emergency. That ADM Jabalpur, which accepted the argument that government made that rights can be suspended. Technically, how that's done is not the issue today. There are circumstances under which rights can be suspended, whether because your right to come to court is suspended, or therefore your remedy of habeas corpus is suspended, or that the very rights that you have, whether they are of speech, of freedom, of movement, of life, etc., are suspended during very special circumstances. That was overruled by the Supreme Court in the privacy judgment. That was overruled by Justice Chud's judgment. Of course, the whole court overruled it. And therefore, it's important to understand what is it that the court was overruling? Was the court overruling the fundamental basis on which the ADM Jabalpur Supreme Court had come to a conclusion that rights can be diluted or rights can be abrogated, even if they did say that it could only be done temporarily, it could not be done permanently. But there is a similar thing that has happened now in the 2G judgment and the Anuradha Bhasin judgment of the Supreme Court, where again, dealing with rights in the circumstances in existence, those rights have been allowed to be abrogated. But again, the court is very clear. This is not something that you can do for a very long time. This can only be done for a short time, for a limited time, and that must be justified grounds and so forth. But my concern is the balancing of rights with security needs of the state and the individual. This balancing itself is something that is still alive, that this balancing done in ADM Jabalpur still remains intact and can be done even today. So ADM Jabalpur has been overruled, but the question is whether the instrument that caused ADM Jabalpur or the thesis that caused ADM Jabalpur, has that been abrogated, rejected, overruled by the Supreme Court or not? And if you go by what has happened in Anuradha Bhasin and in the 4G judgment, which follows Anuradha Bhasin, J&K problem, then of course it seems that the very reasoning is still alive, although the decision. And what is the reasoning? And I think that's caused partly by the manner in which fundamental rights are enumerated in the Constitution. The reasoning is individual versus society. Now that's a very respectable political way of thinking. Should the individual prevail over society? Should the minority prevail over majority? These are very important legal ways of thinking, and it's not that somebody says this is for political reasons, this is wrong, or this is evil, or this is unaccepted, etc., etc. I think we shouldn't get into that kind of argument. But what we should stick with is that there are things that are respectable ways of thinking, that the individual must give way to society. On the other hand, prima facie, the Constitution, fundamental rights seem to suggest that the individual has certain rights that must not be subjugated to society, and they may be harmonized as best as the Supreme Court said when looking at Minerva Mills, looking at directive principles and fundamental rights. They said that fundamental rights must be in terms of the overall directive principles backdrop. And therefore, there is no need to think that there will be a conflict between fundamental rights and directive principles. Now, having said that, the issue about how the 4G judgment was decided, or the ADM Jabalpur was decided, I will just take the liberty to read one short paragraph from Dworkin, written about the time when the American law was trying to come to grips with the threat of full terrorism. 9/11 had happened, and therefore the question was what to do with the rights, as it were, of that is an important, interesting thing that had happened at that time. And I'll just read one paragraph from that article, Ronald Dworkin. The article itself was titled "Error and the attack on civil liberties, written on 6th of November 2003. Now, there's a very interesting approach here. This is the conclusion drawn after going through all the arguments about what was happening in the US and to what extent the courts were taking a particular position. And I read from the article, rights would be worthless, and the idea of a right incomprehensible unless respecting meant taking some risk. We can and must try to limit those risks, but some risk will nevertheless remain. It may be that we would be marginally more secure if we decided to care non-human rights of anyone else. That is true in domestic policy as well. We've run a marginally increased risk of violent death at the hands of murderers every day by insisting on rights for accused criminals in order to keep faith with our own humanity. For the same reason, we must run a marginally increased risk of terrorism as well. Of course, we must sharpen our vigilance, but we must also discipline our fear. The government says that only our own safety matters. Dworkin then judges that finally in his last sentence and says, that is a counsel of shame. We are braver than that and have more self-respect. Now, when we are thinking only of society versus an individual, arguments such as these made by Dworkin, a respected professor of jurisprudence, and not somebody doing it for political comfort or for political support, populist support in a political situation. We need to think very seriously about this. We always see an overwhelming presence of the interests of society over an individual, because if we see that, to come to grief in many, many cases. If we don't, we have a chance of saying that rights are important. They will, elsewhere, they would trump other principles, policies, or decisions to be made at hand. Now, Constitution, as I said, we have directive principles of state policy and we have rights. Now, the directive principles of state policy and the rights are, as I said in Minerva Mills, have been harmonized. So, scope for conflict is not there and we need not worry about real conflict happening there. But there are some judgments in which we could examine that there is an attempt to hide the conflict instead of taking the conflict upfront solution. But be that as it may, when we look at the content of rights themselves, we are looking at some Article 19, Article 21. Now, 19 poses the special problem which rights integrated in
Union Minister of India
don't have.
The former Israel Minister, the former Supreme Court judge, or a judge of National Arbitration in Singapore.
So the Constitution, Article 19, provides the rights that we have. Article 19.1 mentions the rights. Article 19.2 provides the circumstances in which those rights can be restricted or can be limited, but in a reasonable manner. Now, that reasonable manner has been variously amplified. It is not that being reasonable includes proportionality, it includes rationality, it includes the minimum use of attempt to restrict what is being restricted, that the purpose must itself for restriction must itself be a legitimate purpose, and so on and so forth. But the fact remains that the issues on which the right of an individual can be curtailed include elements like decency, elements like morality, elements like public order. In other words, basically the wishes of the multitude in terms of society weighed against the wishes or the preferences or the entitlement of an individual. And in that balance, the court sometimes looking to the individual, sometimes looking to society as a whole. And this is where the balancing of freedom versus security comes in. And Dworkin has very clearly said that you can't be balancing rights like the right of liberty with the right of security. These are two separate things. The moment you start balancing rights of liberty, security, liberty is going to be the loser. And my argument is, but this is only suggestive at present, I think one needs to work much on it before we can get to a point where this can be a firm argument, that it's a similar balancing that was between an individual's freedom or liberty and the rights of society to be an ordered society, a society secure from disorder, secure from the issues that were being raised there, being, in a sense, existential and threatening. Now, why do these things become important? When there is a war, when there are major threats of security, etc., there is one situation, and maybe a lot of people would say that the courts must take a backseat when such things happen, because these things are passing and ultimately they will settle down. But we now know that there are other moments which are very, very trying and very, very pressing, moments like with the COVID pandemic. Now, in the COVID pandemic, world over, people are saying that executive is exerting to take greater power and asserting itself against society or individuals, taking decisions by itself. And courts, even in our own country, feel a little reluctant, shall we say, or a little self-conscious, because they feel they are ill-equipped to be able to take over the responsibility of governance in times of such chaos, in times of such strife, in times of such depression or times of such stress. And therefore, they don't want to make things worse, and therefore they wonder whether they should step in. Now, of course, they do fairly step in, and they have stepped in as far as the migrant labor was concerned. They did step in and say, look, there are certain things the executive to perform which will not necessarily be performed if we don't interfere, and therefore the courts do step in. But my question remains, they step in, it's a great thing, it's a good thing, and finally it sorts out things for the executive as well, because sometimes interference by courts may appear to be adversarial as far as the government is concerned, but at the end of the day, the government gets a lot of burden off its shoulders. The government is able to get the assistance in which it needs from the courts and the judiciary, and the government is able then to fulfill its task without feeling a sense of being completely unprotected and being unassisted by any other major institution of the country. So these are important factors, because world over people are saying that governments and executives are trying to grab more power. Now, if that's temporary and it will change with the return to things will return to what they are, difficult to tell, but one can assume that that will happen. What happened after the emergency in ADM Jabalpur is that the government had tried to take a lot of power. The court did hold back, did allow the government to do so, but then after that period was over, the court asserted itself or reasserted itself, and we saw those wonderful judgments that came from Menaka Gandhi to a series of judgments that followed, and finally Article 21 was given a virtual new shape, what some people talk about a rewritten constitution by the judiciary, which gave life all the meaning that the several judgments of on Article 21 have given to life, which was bland life at one time, life and death. Today, it means life with liberties, life with a lot of amplification of various elements that makes life worth living. And of course, along with that, the court having come to the conclusion that they are overlapping, that they are interconnected, and therefore 19 can assist 21, 21 can assist 19. That is given a wholesome approach to fundamental rights. But I still would argue that fundamental rights, unless we sort out this issue between individual and society, which is, as I said, respectable thesis in many Western countries, society, or society prevails over the individual. Many social welfare states think that society must prevail. Other purist right thesis people believe that rights of an individual must prevail over society. Questions which are today related to this topic in the sense of dissent. Now the court has made it very clear, the Supreme Court has made it very clear that dissent, disagreement, or voicing of your opinion, so long as it encourages violence, is perfectly acceptable within your parameters of free speech or conduct or behavior that you're allowed to. It's only where it instigates violence that there would be a problem. But if you see this in the backdrop of individual versus society, there's a likelihood that enforcement agencies will make a mistake. This is happening now in the what is said, taken to be unacceptable to the government of the day, is then interpreted by policing authorities as being akin to sedition. Now, very clearly, the Supreme Court doesn't support this. Supreme Court says if you don't advocate violence, then there can be no restriction on you. The question really is that restriction of what nature? Some judges would say, disagree, you must disagree in terms that are pleasant, in terms that are not unpleasant. But Dworkin might argue that if you disagree very strongly, then your words also must be very strong. Of course, the line with violence will have to be drawn. Anyone who instigates violence, advocates violence, supports violence has reached a no-go area. But short of violence being insulting, being aggravating, being provocative, etc., will that also fall on the wrong side of the line, red line, or will it fall on the right side of the line? I think it's very important to know what the measure of this has to be and how that measure is to be put into operation. This is, I believe, an interesting proposition, and since, as I have said earlier, Justice Sikri is here, we would be greatly benefit from the response and reactions that we have from Justice Sikri. This is my short and COVID period tribute to Ronald. Thank you very much.
Thank you so much, Mr. Khurshid, for a brilliant exposition on Professor Dworkin's take on today's situation. You have molded it so well. And it is true that we need to find the right path to balance and harmonize the individual and the society. And it remains to be seen how the society and how the judiciary is able to tackle that. Justice A.K. Sikri, former Judge, Supreme Court of India, and Judge Singapore International Commercial Court, is a distinguished professor judge. I say distinguished because not only does he look distinguished, but he also dazzles us with his humility and leaves us breathless with his display of wisdom. We could not have found a better philosopher to preside over today's Professor Ronald Dworkin Memorial Lecture. Ladies and gentlemen, Honorable Mr. Justice A.K. Sikri.
Yeah, thank you, Shruti Bedi. Thank you very much, and for your generous introduction about me. And rather, I would say that it gives me a pleasure to preside over this lecture, which is an outstanding lecture which has been delivered by Mr. Salman Khurshid. He completed it just now. And taking this topic in the context of the philosophy of Dworkin, and then in such a short span of time, he has tried to cover all the essential aspects of it. And if I may say so, uh, of course, when we talk of dissent, uh, that first I'm trying to convey the message of Mr. Salman Khurshid, and then I'll try to add something more to that. He says that look, there has always been, uh, in a way, struggle or tussle between the individual rights and the societal rights. And normally, whenever this thing happens, one has to do the balancing. And in such balancing, it is the individual rights which are normally sacrificed in the larger interest of the society. Of course, he has explained beautifully that while doing this balancing, as Supreme Court has said in various judgments, that we have to adopt the principle of proportionality, that the invasion into the rights of individual are not more than what is required, and rationality principle which he stated. And then coming to the and in the process he has explained that look, the basis of the reasoning given in ADM Jabalpur in a way remains valid even today, as it has happened recently in two judgments of the Supreme Court in 4G and Anuradha Bhasin. And coming to the aspect of dissent in particular, uh, he has beautifully summarized that yes, dissent is a right of everybody. It is a right which is inherent in the right of freedom of speech, which is guaranteed under Article 19(1)(a), but then that is subject to the limitation which is imposed in sub-article 2 of Article 19, that in the interest of decency or for the security of the nation, etc., there can be curtailment of this freedom of speech, which includes dissent as well. But at the he has also given a message that at the same time, it is not for the government of the day to unnecessarily perceive every dissent as seditious or as contrary to the national or anti-nationalism, etc. Now, having said so, and as I said, he has brilliantly covered all these aspects. Let me try to approach this very subject in a little, of course, I would maintain the same uh, uh, as far as the foundation is concerned, but try to convey it in a different manner as well. I think that is the permission which is given to me as when I'm presiding over. Now, you see, I go back to social contract theory, which was propounded by Thomas Hobbes. And that social contract theory, where people come together and they want to create a state, nation state. And so they give the power. They will say that in that social contract theory, that we will elect our representatives. And now I'm straight away coming to the present form of democracy, of course, not going to the transition of this theory, because that is not the subject matter. But there is a reason because of which I'm emphasizing of this social contract theory, is that the people say that yes, we will elect our representatives, and we give them the status of legality. We authorize them to have the governance. So a nation state is created. In that nation state, which we say, as our constitution also say, we the people. We have given that constitution to ourselves, and the constitution talks of elections, etc., and the majority government which can be formed, and which will govern for next 5 years till the time second elections. I mean, next elections take place, and the power still remains with the electorate, in the sense that after 5 years they have a right to see whether we have to re-elect the same set of people, or we have right to bring a change and another set of people if according to them they have not worked or they have not governed properly. So in that sense the sovereignty remains with the people, we the people. But then, in order to have, this is what Thomas Hobbes also said, that in order to have a society which is not having a jungle raj, but which is governed by rules or and where power is given to few people so that they are able to govern. Of course, without going into detail, I am saying this theory was improved by Kelsen and Hart, and they said that look, even if we give power to few persons, but then they may become despotic. It is not necessary that in when there is no society in the sense which is governed by those few people, and there may be any might is right, which is a state of affair when there is no state. And that is how this Hobbes created Leviathan, the concept of Leviathan. But he recognized that even in such a case, the one person to whom we are giving, or group of persons to whom we are giving the authority, they may become despotic. But then it is better to have this kind of despotism in the hands of few persons than there's no governance at all in the society. But then, as I said, Hart and Kelsen, they said, sorry, that doesn't mean that the people, if they are, so we, to that extent, we don't agree with what Thomas Hobbes has said. They improved it further. They said that it should be then persons to whom we are giving powers also should be the persons who are also subjected to rule of law, some norms by which they have to govern, and they should not go beyond that. And to cut it short, the entire story, that is how we get in the present form in all the such nation states which are democratically governed, the constitution, which is the constitution is the instrument of governance. And here the power is not only given to electorate, they are the parliamentarians, okay, but then separation of powers is there. They will so part of power is given to them to make laws. Executive, the majority which forms the government, will execute those laws, make the policies, but then the judicial power is given to the judiciary. So separation of state with independent judiciary, which becomes a very important in the whole governance, and which will uphold the rule of law or enforce the rule of law. So here concept of limited government comes, which I wanted to say. In this social contract theory, the concept of limited government comes. And limited government means that the government is also a government, elected government, which may be a majority government because people have elected them. But then this is the government which is to act within the sphere allotted to them, and that is all delineated in the constitution. So therefore, parliament today can make laws, but it is not supreme in the sense that it can make law on any subject. It can make law only in respect of 7th schedule entry 1 and concurrent power in respect of list 3, list 1 and list 3. Insofar as list 2 is concerned, in the concept of federalism, it is state. So any law made by parliament which is not covered by that can be declared as unconstitutional. But without digressing, without going into that, the purpose was to say that even it has to act within the scope of within the parameters of the constitution. Now, constitution, and when I said social contract theory, the bedrock of this social contract theory is liberty, liberty of the people, which is very, very important. And it is said that by no means the liberty of the people have to be sacrificed in the whole process, because when we the people elect our representative and give them the power, that doesn't mean that in the process our liberty is taken away. So that is why in the constitution, in the form of fundamental rights and article 19 and 21, they 14 and other articles, they ensure the liberty of the people. And in this process, now how to do that. The first aspect which Mr. Salman Khurshid said about the rights of the individual and rights of the society. These are the two facets of constitutionalism in any constitution. On the one hand, we call some rights which are given, which are in part 3 fundamental rights, and all these freedom and liberties which are given, which cannot be taken away. These are, and along with that, some basic feature of the constitution, which includes separation of power, which includes democracy, which includes independence of judiciary. These are the negative attributes of the constitution. On the other hand, what Mr. Salman Khurshid mentioned was about the security and about the larger public interest. Yes, here these are these are contained in our directive principles, and this is social welfare, solidarity, economic equality, social justice, etc. These are described by jurists as positive attributes of constitutionalism. No doubt, in the whole process, balancing has to be done. But today's topic is about the democracy, dissent, and the Indian Supreme Court. So therefore, when we are talking of dissent, and here I am coming, no doubt the people have elected a particular set of people, and in a political party, they are the majority persons. So they have a legal right to govern. But that legal right to govern does not mean that any government election become despotic, as I said. And that is why concept of limited government. And that is why the rights of the people which are to be protected, and the courts, judiciary comes to protect that. Now, there's a very interesting studies in some of the books that it is not necessary, if we go into the history, that even it's not that only when dictators come and they govern that they take away such rights. Many times even the elected governments, they behave like that. In the history, we have example of Hitler, we have example of Mussolini, and if you see the history in last 20-25 years in many countries, it has happened. So therefore, in the whole process, what I'm trying to say is that the merely because majority has right to rule does not mean others which are in minority, or even those including, we suppose even we voted that particular government into power which is ruling, that does not mean that and suppose I had given the vote, but tomorrow some of the actions taken by that government, I have no right to give my dissent, and I have no right to object to what is done is right or wrong. This is a very powerful weapon in any society for proper governance and for good governance, that is right to dissent. And this right to dissent not only flows from freedom of speech, no doubt about it, but it is the fundamental of any democracy. If the democracy has to survive, and if the democracy has to flourish, that then the government of the day cannot throttle the dissent. It has to respect the dissent, because as we know, which keeps happening every day, as far as the judgments of the court are concerned. Suppose a particular judgment is given, and there is a dissent. It's a constitutional bench judgment, and suppose it is 4:1 or 3:2. No doubt what 4 judges have said become the law of the day. But then this dissenting judgment has also its own value, and there are uh, instances galore where the minority today became majority tomorrow, when the opinion given by the dissenting opinion given by minority judges was accepted, and the majority opinion was overruled. So this, what I'm trying to say is that merely because a majority rule is there, and every policy of that government and every decision taken by that government may not necessarily be correct. So whenever individual or each decision is taken or each step is taken, and other persons are saying that, look, there are some persons who raise their voice and dissent to that particular policy or particular decision, in a good democracy, in a sound democracy, that right becomes very, very important, and that has to be given. Now, question that arises is, in this context, is that what this is the essential of democracy, and this particular right, as Dworkin, because we are talking about in a Dworkin's memorial lecture series, he has said in his book A Bill of Rights for Britain, and I quote, not just a statistical democracy in which anything a majority or plurality wants is legitimate for that reason, but communal democracy. Here it means democracy of a community, not communal in the sense that religious sense, where everyone must be allowed to participate in politics as an equal. Political decisions must treat everyone with equal concern and respect. Each individual must be guaranteed fundamental civil and political rights, which no combination of other citizens can take away, no matter how numerous they are or how much they despise his or her race or morals or way of life. So, notwithstanding all that, it has to be, I mean, respected, and therefore, it is not that the voice of the dissent or the minority has to be muzzled in a good democracy. And he only, Dworkin further says, and I'm saying in my words, that right of conscience and speech as basic human rights are a matter of liberal political theory. So therefore, if we when we talk of a democracy and the rule of majority, that democracy is simply not a rule of majority. No doubt that is a validation given to that majority to rule. But in any substantive democracy, in any liberal democracy, the rights of others are also be respected, which includes in a big way the right to dissent. And the question is, in any I mean democracy, any elected government also, whether in a given particular given case, a right of a person to dissent. Of course, Article 19.2 gives the exceptions and says that there can be, I mean, law and laws are made, that we have anti-sedition law, we have anti-defamatory laws, we have laws which protect the decency, etc., under IPC. But the question that arises, and the fundamental issues which arises in given circumstances, what is happening, whether what is said by a person while putting his or her dissent to the insofar as the government policies are concerned, whether it is a fair criticism, or it is amounting to such a speech is amounting to anti-national, or it amounts to sedition, or it is defamatory, etc. Now, so therefore, these laws may be valid, but in a given situation, going by a particular speech, or going by a particular, article written or any such thing done by a person, can it be, can it come within the scope of that? And the democracies fail, according to me, when such powers which are with the government are misused and misutilized. So here comes the role of the judiciary. Here the judiciary has to ensure that the rights of the persons, including the dissent, are protected and they are not muzzled. And in as far as Indian Supreme Court is concerned, of course, as Mr. Salman Khurshid has already mentioned, there are such rights have been recognized by the Indian Supreme Court. I'm not talking about now the balancing of the rights, etc., but freedom of speech, which has been recognized in various cases, and the value of dissent has been highlighted a lot. Actually, I was without realizing, when this topic was given and I was looking into it, 3 judgments are mine only on these aspects. Now, in one case, it was Mazdoor Kisan Shakti Sangathan case, where the government has passed the orders that you cannot have these demonstrations, etc., at some places, and it is only at designated places where you can hold demonstration in Delhi. So in this Mazdoor Kisan Shakti Sangathan, while saying that, look, it doesn't meet the test of the proportionality, etc., you may put some embargo. Yes, it should not, as Mr. Salman also said, that it should not assume the this character of violence and violence, but then a law and order is in your hand, and you have to ensure that how it can be protected. But what I said was that legitimate dissent is a distinguishable feature of any democracy. Question is not as to whether the issue raised by the, now this is very important, question is not as to whether the issue raised by the protester is right or wrong, or it is justified or unjustified. I have a right to project my view. I may be wrong, but I can't be hauled up for that. The fundamental aspect is a right which is conferred upon the affected people in a democracy to voice their grievances. Dissenters may be in minority. They have a right to express their views. A particular cause which in the first instance may appear to be insignificant or irrelevant may gain momentum and expect acceptability when it is duly voiced and debated. We know, if we go by our history only, all those social reformers who initially voiced against the some I mean practices which were there at that time, take of sati pratha itself, so they were condemned because society felt otherwise. So they were in minority, they were condemned, but ultimately it was accepted. So therefore, we can't just denounce that majority says that no, what you are saying is wrong, and therefore you have no right to say so. So therefore, this valuable right has to be protected. Yes, at the same time, as it was pointed out by Mr. Salman also, that it cannot turn out to be a violent this thing dissent, and that is again we had held in one of the cases, that was Bimal Gurung versus Union of India in 2008. And another thing which is very important, third case which I'll refer to, and apart from other cases, where again it was some demonstration which had taken place in Jammu and Kashmir. Some persons, they said that, look, our rights are not given properly to us. They were voicing their voice, I mean agitating, and they wanted to come march up to Delhi, but they were stopped at some particular place in Kashmir, and they stayed there for 2 days when they were stopped by the forces. But ultimately, just to disperse them, the forces adopted this, I mean, force. And in that process, some of them were injured, etc., and they filed the writ petition under Article 32. And we said that by controlling this demonstration, the police cannot use the power which is more than required, and therefore it amounted to muzzling, and we had adopted, we had granted some damages also to those demonstrators. So therefore, what I say is, at the end, that of course dissent has its own value. It has to be protected. It has to be, I mean, nourished. It has to give its due weightage. It may ultimately have, and if I may say at the end, it is even based on the concept which Professor Dworkin adopted, that is of dignity. I will come to that, and then I'll finish with that. It is, according to me, dissent is a part of dignity. Why I say so? Because Professor Dworkin talked about individual choices. So if I have a choice, and that is my right, which is based on dignity, then I have a right to express my views in whatever way, within, of course, lawful means, in whatever way I want to express. So in order to have my own growth, individual growth, and as an individual right, dignity in a way becomes another limb of right to dissent. So that is what I wanted to say. Thank you.
Thank you so much, Justice Sikri. Again, I can only say that it's been a beautiful knitting of the right to dissent and the right to dignity in a democracy. It couldn't have been uh, discussed in a better manner than what you have done and portrayed and made it so simple for everyone to understand. We are extremely grateful for your words today, sir. There are a few questions that some of the participants are wanting to ask. So if I may be permitted, I can ask a couple of questions since we are short on time. Mr. P. Kumaran, I mean, either Mr. Salman Khurshid or Justice Sikri, either one of you can take the question. So Mr. P. Kumaran, it's there in the chat box, but I will read it out to you. He says, many cases are pending before the Supreme Court relating to the disqualification of MPs and MLAs. And how does the Supreme Court maintain democracy in view of the politics played during the judicial rule, and how do we control it?
Yes, Mr. Khurshid, you answer.
I thought that if it's about the Supreme Court, Justice Sikri will answer it.
No, I tell you, so there have been, you see, it also becomes a, when we talk about the role of the judiciary, insofar as upholding, I always say, and I have said in my judgments also, and I have taken this from Aaron Barak, the ex-president of Israel Supreme Court. There, instead of Chief Justice, the nomenclature is president. So you can say Chief Justice of Israel Supreme Court, former Chief Justice, who has said that in any democracy, and liberal democracy, not formal democracy, as that is what we have been discussing. The judge has the, apart from deciding day-to-day cases, etc., two fundamental roles which judge has to perform. First role is to uphold the constitution and rule of law, and second role is to bridge the gap between the law and the society. If I say so, to upholding the constitution and rule of law, that is the rights of the individuals, etc., fundamental rights, we generally talk about chapter 3, and this is what I said, negative to upholding the values of negative constitutionalism. When it comes to bridging the gap between the law and society, we talk of social welfare, economic welfare, and I mean, elimination of economic inequalities, etc. So there we talk of, say, part 4 of the Constitution. Of course, now there are many judgments of the Supreme Court where part 4, although is non-justiciable, but is almost made justiciable by incorporating many of the provisions, reading them into the fundamental rights like Article 21, etc., including the privacy, which is said that it can't be traced only to Article 21. It can be 14, 19, 21, all. But what I'm trying to say, if you see the judgments now in the context of the question which is asked to me, judgments of the Supreme Court over a period of time, so far as governance is concerned, from that angle only, to democratic, upholding the democratic principles and the constitution and the rule of law, and political judgments which have been given, there are many remarkable judgments which have been given. Say, of course, I give you simple example of cleaning the electoral system itself, or the political, because everything starts at election when we talk of democracy. So the judgment where the candidates will disclose their assets, the judgment where if they are involved in a criminal case, they will disclose that, the judgment that it is not necessary for every voter to vote either in favor of or against a candidate, or in favor of one or the other candidate. You can have none of the above, NODA. So therefore, all these judgments and various other judgments have been given. Now, there are individual judgments which we have also dealt with when it comes to a particular disqualification of a particular MLA or MP who had contested the matter. Such cases, whenever elections take place, such cases crop up always, and there are in numbers. So not that the Supreme Court is not dealing with these cases, but then of course we are bogged by numbers, that is arrears in the courts. There are so much, no doubt. From time to time directives have been given, even the government has desired, even within that many chief justices who have come, given directives that such cases should be given a primacy, and they should be decided expeditiously, and even timelines are also drawn. But all said and done, it becomes easy to say so, but it is not possible to decide all these cases in a particular given time, going by the factor that there are so many other cases pending. And ultimately, I would say, you cannot, the Supreme Court also cannot interfere with each and every kind of matter, political matter. Of course, there are certain matters which may be totally pure political in nature, and we have to, adhere to the principle of separation of powers also. At the same time, I'm not defending the judiciary. I agree that such cases should be decided immediately, because term of a particular MLA or MP is 5 years. What is the use that when the election petition is filed in the High Court, and by the time it comes to the Supreme Court, 5 years had gone by, and even if thereafter election was held to be, the person was disqualified, or he indulged in what we call this corrupt practices, etc. But ultimately, that would be of no use. So therefore, no doubt such cases should be decided expeditiously. I agree with that.
Thank you so much, Justice Sikri. We have time for one more question. So I will address the second question to Mr. Salman Khurshid. It's from Shivang Singh, who is directly addressing it to Mr. Khurshid. The question is, would you agree that draconian provisions of the anti-defection law, such as not being allowed to vote against the order of the party whip, need to be done away with to facilitate a more democratic deliberation on matters in the parliament and legislative assemblies? It seems like individual voices are being lost to majoritarian politics today, which is alarming for a democracy as large as ours. Mr. Khurshid.
We've just been talking about balancing throughout. Here again, it's an issue of balancing. Someone gets elected on a particular managed party, on a party platform, on a party ticket, and then is one dimension that has to be considered. But that somebody's voice is stifled entirely is another dimension. Now, people have found a solution of this is that they speak up, but they speak up against the party whip, but they don't vote against the party whip. That I think is a wonderful way to balance, that you upset the balance of the government, having been elected on behalf or for the government, but that there should not be the fact that you speak up against some position because you believe it's wrong, that should not be used to stifle your voice. So I think that this is not such a difficult thing in which a suitable compromise and a suitable balance cannot be found. I think looking at it in a draconian fashion, we must also keep in mind that people have been misusing the freedom that they seek by to destroy parties, to bring down and to make deals for themselves. So I think that also, since both the judiciary and Parliament wanted to discourage that, that's why these laws were made. But I'm quite sure that there's enough flexibility there that could allow a person to speak, but required to leave the Parliament in case he believed that he wanted to vote against the party that brought him to power.
Thank you so much, Mr. Khurshid. And that is exactly what our lecture, as you said, was about, which is the takeaway from today. There are quite a few questions that we are having, but I must apologize on behalf of everyone because we have run out of time, and maybe we can have another session.
Just send them to us by email. Just send
I will share. I will share your email ID, sir. I will share. Thank you.
Thank you.
I would now talk about the expression of gratitude, which will be delivered by Professor Yogesh P. Singh, who is a professor of law and the registrar of the National Law University, Odisha. His areas of specialization include constitutional law, comparative constitutional law, criminal law, and the list goes on. He has published extensive...
He has written a wonderful book on dissent.
Yes, sir. Yes, sir. Absolutely. He is well known for that. And moreover, he is a combination of intellectualism and humility, like you. Professor Yogesh is also a columnist and writes extensively. Professor Yogesh P. Singh, may I request you to deliver an expression of gratitude on behalf of the Ronald Dworkin Study Circle and the National Law University, Odisha, for today's lecture.
Thank you, Professor Bedi. I feel privileged to be part of this special panel consisting two very stalwarts of the Indian legal fraternity, Mr. Salman Khurshid and Honorable Justice A.K. Sikri, and two very young, dynamic professionals like Dr. Lokendra Malik and Professor Shruti Bedi. When Dr. Malik proposed this topic to me that we can organize a webinar on democracy, dissent, and Supreme Court, I readily agreed because this topic is close to my heart. When I had opportunity to work in the Supreme Court for some time, and I did a small research on dissenting aspect of the judicial making process, how dissenting opinions are given and how dissenting opinions have contributed in the development of law in the through Supreme Court judgments. And during this research, I tried to explore when this particular question, why do judges dissent? Then I had to study and I had to read the writings of Ronald Dworkin. And then I found it very, very interesting and very relevant even to decision-making process which is going on even today. Especially the Hart and Dworkin debate, where Hart in his book Concept of Law, he said that legal rules are generally indeterminate because there are many ambiguities in laws and legal rules, and when it comes with this open texture, it comes before the judges, then judges has to exercise discretion. But the Dworkin in his writing, he says that the kind of indeterminacy which Hart has discussed is exaggerated. Even in hard cases, he says that in all cases, including the hard cases, when a matter comes to the judges has to give a correct answer, only one answer, and that he can either do on the basis of policy or sometime on the basis of principle. But there are other jurisprudential developments later also when American realist and critical legal school have come up. So I have discussed, and I had the privilege when my book was published. I had the privilege that Justice Chandrachud agreed to write a foreword for my book, and I take this honor that after writing the foreword, he wrote 2-3 very good dissenting opinions in the Supreme Court. And I also had the privilege that Justice A.K. Sikri, he agreed to release my book in the Indian Law Institute. And that's why we organized this debate. And I heartily congratulate Mr. Salman Khurshid sir on behalf of National Law University Odisha for agreeing to deliver this lecture and for making this discussion relevant and creating our interest and interest of all the participants in the writings of Ronald Dworkin. And I thank Justice A.K. Sikri, because every time he is so humble that every time we request him, he doesn't say no. So thank you so much, sir, on behalf of National Law University Odisha. And on our behalf, we thank you from bottom of our heart that we'll organize more lectures on such topics, because this is relevant, because the topic which we chose, it covers both kinds of dissent in general, and dissent with respect to the decision making process in the Supreme Court and High Court. And I find that it is more relevant because both are declining in the today's political scenario. Both kinds of dissents are declining. So this kind of debates and discussions are required to create interest and to make people aware that why dissent is important, why dissent is important in today's time. I thank Dr. Loken Malik also for taking this initiative and organizing this and involving me also in this program, in this webinar. I thank Professor Shruti Bedi for beautifully moderating this program and successfully organizing. And we'll organize such programs in future also. I thank all the participants who participated. I can see Professor Balram Gupta also. He was sitting and listening the lectures given by Salman Khurshid sir and A.K. Sikri sir. So I thank all the participants who participated, and thank you everybody.
Thank you so much, Professor Yogesh Pratap Singh. Indeed, it's been a pleasure to have the two brilliant stalwarts of the legal profession here with us today. And thank you to the entire audience. And I have, in the chat box, I have written and shared the email ID of Mr. Salman Khurshid. If there are any questions, you can address it on that email ID. Thank you, everyone. Please stay safe and take care.
Thank you.
Thank you.
Okay. Should I leave?